Here at Scott Legal, we know the ins and outs of immigration. We are here to help you navigate the oftentimes complex road in achieving your immigration goals. We have new immigration videos every week. If you are new to the channel, please hit the subscribe button and bell. You can also sign up for one of our webinars, or get a free immigration guide, by clicking the link below.
How do I know if I am eligible to apply for legal permanent resident status, through the adjustment of status process, without having to depart the United States?
Let's find out. Adjustment of status is the process where a non-citizen is permitted to apply for legal permanent resident status, also known as a green card, while present in the United States. Not all non-citizens present in the United States will qualify for the adjustment of status process, and at a minimum, non-citizens must demonstrate that they have lawfully entered the United States and maintained a valid immigration status when applying for the green card through the adjustment of status process. Although this rule applies to most non-citizens, it should be noted that there are exceptions to this rule that can disqualify the non-citizen from the green card, despite the fact that the non-citizen entered lawfully and maintained status in the United States. Therefore, the circumstances surrounding the non-citizen's presence in the United States must be determined, to conclude whether the non-citizen will be eligible for the green card or is barred from applying for the green card through the adjustment of status process. The immigration law that controls the potential bars from adjustment of status is found under Section 245C of the Immigration and Nationality Act.
What about non-citizen crewmen?
Non-citizens who enter the United States as a crewman appear to meet the criteria for adjustment of status if they entered lawfully and are in lawful immigration status. However, these non-citizens are specifically disqualified by law from applying for a green card through the adjustment of status process.
What about non-citizens who entered the United States lawfully, but fell out of lawful immigration status, or who accepted unauthorized employment?
Remember, the general rule to qualify for adjustment of status is entering lawfully and maintaining legal status. So, when a non-citizen entered the United States unlawfully, or failed to maintain lawful immigration status, this will result in being disqualified from the adjustment of status process. Also note that even if the non-citizen entered lawfully, and has maintained lawful immigration status, if the non-citizen accepts employment without authorization, or violates a condition of his temporary immigration status, this will also cause the non-citizen to automatically fall out of status. As a result, they are disqualified from the adjustment of status process.
What about non-citizens admitted in transit, without a visa who stayed in the United States?
Similar to crewmen, although a transiting non-citizen may appear to meet the general rule to qualify for adjustment of status, where the non-citizen entered lawfully. If the non-citizen extended the transit period, this will disqualify him or her from the adjustment of status process.
What about non-citizens who entered the United States under the Visa Waiver Program?
Non-citizens from certain designated countries qualify for admission into the United States without a visa. The Visa Waiver Program exists to facilitate travel to the United States without needing a visa for the same purposes as a B1 or B2 visa. However, this travel is valid for 90 days, and since these non-citizens do not require a visa, they are expected to return to their home country within the 90-day period. Due to the more relaxed requirements for entry into the United States, and temporary nature of travel, these non-citizens are explicitly disqualified from applying for a green card through the adjustment of status process.
What about non-citizens who have been involved in terrorist activity?
This applies to non-citizens who have engaged in terrorist activity, or who present a reasonable ground to believe that they have engaged in or are likely to engage after entry in any terrorist activity. Remember that these are automatic bars to adjustment of status under law. Regardless, it is still important to consult with an immigration attorney about potential eligibility. Since immigration law allows for some exceptions to these bars under certain circumstances, that may still permit adjustment of status despite falling under one of these bars. To learn more, take a look at our resources in the description box below. You can also sign up for a free visa guide, any of our upcoming webinars, and Facebook groups. You can also schedule a consultation for a date and time that is best for you. We are here to help. You can contact us by calling 212-223-2964 or by sending us an email. We look forward to hearing from you.